We're diving deeper into the legal battle over the shooting at Richneck Elementary School. Defense attorneys with the Newport News School Board filed a motion yesterday to dismiss first grade teacher Abby Zwerner's $40 million lawsuit.
It accuses school administrators of ignoring repeated warnings about the boy who fired the gun. The school division responded saying her claims related to the shooting fall under the Virginia Workers' Compensation Act. And Sparaco spoke with a legal expert today to see how these legal proceedings could play out in court. And
David, Nicole, we know it can be hard to keep up with this complicated case. In this latest motion to dismiss Abby Zwerner's lawsuit, attorneys representing Newport News public school administrators argued the first grade teacher's injuries fall under the Workers' Compensation Act. However, a law professor I spoke to today says Zwerner's team could have a strong argument against that in court. The argument over workers' compensation has become the center of first grade teacher Abby Zwerner's lawsuit against Newport News Public Schools months after the Richneck Elementary shooting. In Zwerner's lawsuits, her attorneys argue a liability claim, otherwise known as tort law, saying school administrators ignored warnings that her 6-year-old student had a gun the day of the shooting.
Workers' compensation governs injuries that arise out of the employment.
Regent University professor Louis Hensler says it's typical for a person hurt on the job to seek a liability claim to gain more coverage than what the Workers' Comp Act would offer. But he says it all comes down to what proves this shooting did or did not happen because of Zwerner's employment.
I think it favors her a little bit. This is an elementary school, because usually you don't expect to be attacked by your elementary school students.
In a statement, the school division's attorneys say the student's use of a gun instead of another tool to hurt his teacher does not change the fact that the incident happened at Zwerner's place of employment. Hensler says the argument doesn't necessarily come down to the expectation of workplace dangers.
I don't think anybody, including the school district, is arguing that she voluntarily assumed this risk. But I think the question is, did this injury arise out of her job? And if it did, workers' compensation could be her exclusive remedy.
And Hensler says this all comes down to if the judge agrees with Zwerner's or the school administrator's arguments. From there, the judge would determine if this case should go in front of a jury.
well, Ann, yesterday you covered a lawsuit by a former Chesapeake Walmart employee who's trying to hold that retail giant liable for getting hurt in that mass shooting.
Yeah, Walmart's attorneys also argue that the employee's injuries fall under workers' compensation. So how are these cases different?
Well, Nicole, David, the Walmart case involves an altercation between those two employees in which a manager of the store opened fire in a break room and allegedly chased after and shot at the employee, who's now filing this lawsuit against the superstore. Whereas Abby Zwerner's case is a little different because it involves a student and a school employee versus two employees. So Hensler says those cases would be argued differently in court. Definitely an interesting series of developments in these cases.
Yeah, it is. All right. Ann, thank you.